SJC-13384, Commonwealth v. Bradley T. Zucchino.
All right. Attorney O'Connor.
Good morning, Chief Judge Budd.
Good morning.
Justices, may it please the court. As always, it's an honor to appear before you. This case presents the question, in what OUI prosecutions is consent to state testing and analysis of blood required under Chapter 90, Section 24, 1E? And the answer to this question, Your Honors, is also going to determine when, in what cases did the legislature determine that refusal evidence is inadmissible? In what cases did the legislature determine that BAC evidence should be automatically admissible, that the prosecution should be spared the obligation of presenting a live witness to establish the BAC and instead use a certificate of analysis? In what cases did the legislature intend presumptions of impairment or non-impairment to apply? What cases should the police officer's arrest decision be protected and comparative testing available?
Okay, so that sounds like a lot of things to think about, but can you tell me why we shouldn't just look at the plain language of, I think it's, is it C? Let's just look at the plain language of the simple OUI.
Sure, yes.
Right, that's what you want us to be looking at, right?
I want the court to look at the first, as we should always, look at the plain language of 24(1)E, which is the implied consent, which is the statute which imposes a consent requirement, and to do so within the whole overall statutory scheme. So,
because if you don't do the overall statutory scheme, then you don't have an argument, right?
well, I don't know, because it's actually my belief that if you really look at 24(1)E through the common phrases that are used within that statute, the reading which I propose is proper, is I would say natural and perhaps even plain from the statute.
For a violation of paragraph A, right? That's the magic,
yes, that's right.
word.
In a prosecution for a violation of paragraph A.
And it doesn't say elements like some of the other statutes.
Right. Yes. Although I don't think that it's uncommon in legislative acts to refer to other provisions by reference. For instance, I mean, if you look at the jurisdictional grant for district court, I mean, everything is listed by statute as opposed to by particular names of charges. So what we're talking about here is a prosecution for a violation of paragraph A. So when we look at what is a prosecution for paragraph A, what we're talking about really is a prosecution for OUI. What I would first point out is there's really two statutes at issue here. There's 24L, which is the serious bodily injury statute, and 265.13.5. If I could begin with 13.5, that statute itself uses the same exact incorporation language as does 24(1)E. It defines OUI by reference to paragraph A 90.
What do we make of the language in Bohegian?
So I think that the language in Bohegian is was sort of a side issue because Bohegian was decided pursuant to 24(1)F, wholly apart from 24(1)E, and so
wasn't one of the charges in Bohegian 24L?
Yes, it was. Yes, it was,
So
Justice
it
Wendland.
wasn't dicta. It was clearly part of the holding. Or can you explain how
Sure.
you're differentiating that?
The way I understand, what becomes precedential and what doesn't depends on what is essential to the holding. And the holding was that the defendant's consent was required, and that holding was arrived at pursuant to 24(1)F, wholly apart from 24(1)E. And so, whether 24(1)E applied or not was really not necessary to the court's resolution of Bohegian. And I certainly understand the sort of like arm's length appeal of looking at 24(1)E that way, although I do note that the court's comments regarding 24(1)E before ultimately moving on to 24-1F, were not supported by any citation to authority at all, and thus essentially overruled sub silentio all of the case law from 1989 until Bohegian, all of which presumed that 24-1E applied to all OUI offenses, not just simple OUI. And I think that there's a preference for not overruling cases sub silentio.
I'm sorry, can you list the cases that you're talking about?
Yes,
were
that would be
overruled by the-
these cases are listed within my brief at page 18 through 19 and 47 to 48, and they are Commonwealth versus Ames, Commonwealth versus Woods, Commonwealth versus Zavitas, Commonwealth versus McCravey, Commonwealth versus Davidson, Rivet, Smith, Aruda, Carson. All of those cases. Yes, yes.
You
Justice
say all
Stewart.
of those cases, counsel, but I'm not going to go seriatim through all of them, but they really weren't the issue here. I mean, I could just tell you, Aruda was the nurses that just kept asking, and whether it was state action versus non-state action. So it wasn't really the issues that we have here.
Sure. So in that, perhaps in that regard, it's similar to, it was sort of adjacent to the ultimate question.
Sure, but if we're looking at, and you're looking at Bohegian,
Yes.
particularly, and you're saying it was a side issue, I don't know that I would agree with you, because the court really went to great pains to say, we're not construing this other serious bodily injury component, and that was a big deal. So just now, if we go and just look at the statutory interpretation and the stuff that we've used for years and years and years, why doesn't it make sense that we wouldn't read the consent provision in the serious bodily injury, because it's a far more serious charge? And even though the basic stem, elemental stem, is the same as simple OUI, why doesn't it make sense? And I'll add one other question one other part of that for you. Clearly, if you read and you claim that, or we say that the legislature is aware of what we say and what we do, they certainly could have, since Bohegian, and they could have since Moreau, said, hey, we need to make this explicit in the event that rather than going sub silentio and using all of these wonderful Latin phrases, we could just make it explicit.
Sure. So I think that the principle of statutory construction that we look to is has its most force when the legislature has actually looked at the statute and revised it, but the revision didn't go to the issue here before the court. Just because I would submit that the focus of Bohegian was on 24-1F, that one would have to sort of like mind the decision to really get to the 24-1E language, and I don't know that the legislature had that as sort of as pressing a concern as it would have had if 24-1E were the entire basis for the opinion, or if there was a case that held specifically on its merits that 24-1E didn't apply.
So, but
again,
here we are doing it now. So I
Yes.
grew up Bohegian, so I know that was not the direct issue, but
yes.
here we are now.
Yes, for sure.
So-
with the benefit of briefing.
Right. And so I still want to get to how we get past the plain language that
Okay.
says it's only focused on...
I'm going to help you with that.
Yes,
I'm going to help you
please.
with that. So 24-1E was enacted in 1961, and the version of the statute at that time had been in effect since 1931, 31. And in 1931, that was the first time that the statute kind of like parted the Red Sea. At the time, prior to 31, the statute was omnibus in maybe even a worse way than it is today, in the sense that it listed a bunch of offenses. It listed OUI, false licenses, leaving the scene of an accident, et cetera, et cetera. And then in 31, they said, let's pump the brakes here and let's separate this out. And we have 24A offenses, which are OUI offenses, and 24B offenses, which are non-OUI offenses. And so that's where that dichotomy first arose. And so what's most notable, and this is where I think the greatest weakness to the government's argument that this is a plain language interpretation supports the Bohegian view, is that at the time that 24-1E was enacted, there were no other OUI offenses. So the whole entire universe of OUI offenses was properly described and completely described by simply referencing 24-1A. And so when we look at why they chose that language of referring to paragraph A, I think the only reasonable inference is to separate it from non-OUI offenses, which were in paragraph B. Now, since that occurred, every single case has at least adjacently assumed that 24(1)E applies. From Davidson in 1989 forward, there were 27 amendments to the OUI statute following Davidson, and none of them changed 24(1)E to narrow its application to simple OUI offenses. And that included in the 70s after the first aggravated form of OUI was passed with respect to 24G. So, I think we read too much into saying 24(1)A was meant to distinguish aggravated OUI offenses. There were no aggravated OUI offenses at the time.
But when they passed, they didn't go back and change that language.
Exactly, Judge Lowy. But they didn't need to, because they looked at, we assume that they're reading Your Honor's decisions, and they looked at those decisions and saw all of them said 24(1)E applies universally. So to me, that is a strong evidence that the legislature approved of this court's and the appeals court's interpretation. Here's the
You
other
lost
problem
me
with
on
this.
that. Can you say that again? I'm not sure I follow. They after they parted the Red Sea and put it back together again, they don't make a change in that statute, leaving this limiting language in place. So why is that consistent with legislative intent?
Sure. So, I mean, you described it as limiting language. The language is that for any prosecution for an OUI offense, and we know that any aggravated OUI prosecution is also a prosecution for an OUI offense because it's a lesser included offense, such that when we get a verdict on a lesser included trial, the verdict is guilty of 24(1)A. What I mean by that is that the legislature, when they're looking at 24(1)E, could never have anticipated Bohesian because they're saying it's all good. The SJC is doing it the way we want them to do it, which is to treat 24(1)E as inclusive. I hope that answered Your Honor's question.
I think more simply you're saying they didn't have to worry about it because the SJC case law incorporated the more serious offenses.
That's exactly what I wanted to say in a much smarter way. Thank you so much, Judge Lilly. But we got to look past.
But then after Bohesian, there's
Right.
and so I get it up to them. But once we do Bohesian, and again, I was a dissenter in Bohesian, but after we do that, don't they have to make the corrective language, or we assume they think we're right in your view that they're reading all of our stuff so closely?
Sure. I think that what we're doing is conflating awareness with alacrity. And I think that the problem there is that I don't think that the precedent of this court or generally statutory interpretation states that we expect that as soon as a decision is reported by this court, that becomes priority number one for the legislature.
Although OUIs
It was with upskirting. That was the only time ever.
I'm sorry, someone.
The upskirting decision.
Oh, yeah, right, yes,
Then they
yes,
moved.
that
with
was a big one.
Then they moved with alacrity.
Oh, yeah, for sure.
That's it.
Yeah,
And OUI is something they care about. I mean,
Oh,
they're
for sure.
all over
for
that, right?
For sure. But I want to point out just a little bit of caution here. I don't think that the precedent of this court or any court discussing statutory interpretation views as informative the legislature's failure to act in a vacuum. It has to be failure to act when they're looking at the legislation and passing laws on that legislation.
We don't get to the statutory interpretation tools until we get past plain language, correct?
That's exactly right. Although, I think that the case law is clear that even clear language is not read in isolation. So you always have to look at making an effective piece of legislation, what the overall goals of the legislature are, even in a plain language context. But here's the problem here, Justice Gaziano. By looking at 24(1)E as limiting its application to simple OUIs only, we're cutting off our noses to spite our faces, because 24(1)E clearly is a statute of very broad application in terms of the other mechanisms that it has. For instance, eliminating the admissibility of refusal evidence. Now, if the legislature, so that's where that happens. It's within 24(1)E. And so if the legislature is looking at 24(1)E as a narrow piece of legislation, what we have to infer is that they think it's okay
But
to.
I think your problem, though, so you can address it, that's implicit in Justice Graziano's question is, well, wait a minute, it's not absurd to say, okay, we're going to require this for simple OUIs, but not more serious OUIs. And all of these statutory tools, going back to 1931, the Commonwealth's going to say, all interesting, but the plain language only applies to simple OUIs in 21E1, so why am I worrying about all these statutory tools?
Because I don't necessarily agree that the plain language is as revelatory as the Commonwealth says, or that it says plainly in support of what they of their position as
Because you read it as a lesser included.
because I read it as a lesser included, and for a whole host of other reasons. I mean if they wanted to be plain, they could have said 24(1)E shall not apply to aggravated OUI. So it's almost like it's silent. It doesn't say shall apply and it doesn't say shall not apply. Here, can I give you an example? If you look at, so the Commonwealth says that in an ideal world, the statute would specifically enumerate 24A, 24L, 24G, 265, 13 and a half. There's an experiment within Chapter 90, Section 24, where the legislature, in fact, does that, enumerating these specific provisions. This is with respect to the special assessment requirement within 24. So there's this fund, the Victims of Drunk Driving Trust Fund, which is funded by people who are convicted of these offenses. And the statute enumerates the offenses that should apply. It says 24A, L, G. But you know what? It doesn't say 265, 13 and a half. The charge in which people should absolutely be reaching into their pocket to pay for. They killed somebody, right, under 13 and a half, and they did so in manslaughter context. But because of the enumeration problem, somewhere along the way, they forgot to add 13 and a half. But when you use this language of incorporation by saying any OUI offense under Section 24, all assessments and all other provisions that apply to OUI automatically spread out and apply to all OUI-related statutes, making it a much more effective way to describe the...
I ask you one more question?
Yes, of course, please.
So why do you say that the refusal to consent, if we read the first sentence of 24E1, according to its plain meaning, and I understand that you disagree with that, but according to the way Bohegian referred to it, why can't we separate the second sentence about consent? Because that one doesn't tie it to A.
You mean separate out, parse out 24(1)E to some extent? Is that?
Well, yeah, because 24(1)E first sentence is about the A prosecutions, or simple OUI, as you call it.
Yep.
But then there's a period, and then the second sentence says, evidence shall not be admissible of failure to consent, shall not be admissible in any criminal proceeding.
Right, but
regardless of whether it's for simple OUI.
Sorry to interrupt, Your Honor.
Yeah, go ahead.
So it's the way that the statute itself is written. There are so many internal references to the overall principle within 24(1)E that make it clear that it is a uniform statute that is intended to work together harmoniously. All provisions of 24(1)E are intended to work together harmoniously because the second sentence says the results thereof were made available to him. The third clause says that blood shall not be withdrawn for the purpose of such test or analysis. Again, it's referring back to the first clause of 24(1)E. Evidence that the defendant failed to refuse to consent to such test or analysis shall not be admissible. It all relates back to that first sentence of 24(1)E. I had so much more I want to say, but I'm way past my time. There's no more questions.
Thank you.
Thank you so much. Have a great day, everybody.
Okay, Attorney Moriarty.
Good morning, may it please the court. Marina Moriarty on behalf of the Commonwealth. No one has a right to use the streets and public places as he chooses without regard to the safety of other persons who are rightly there. Commonwealth v. Kingsbury, 1908. Here, the Commonwealth asks this court to reaffirm its holdings in Bohegan and Moreau and conclude that the plain language of the statute applies. The court need not look beyond the plain language of the statute where it is unambiguous. There is no legislative history evincing an intent to the contrary, and it is consistent with the legislature's thoughtful balancing of competing interests.
Was there actually, I'm sure you've looked at the cases on page 18, 19 of the blue brief. Was there actually case law applying E in the context of aggravated OUI before Bohegan?
Yes, however, that was not the issue in the case. I would say that here, the legislature.
Meaning they assumed it
Yes.
applied? Yeah.
Yes, it was never raised.
So, but
They just mentioned it in passing when they were talking about consent, and
Correct. And other,
so you had a crime that there was an aggravated crime, and it said this was, and they mentioned the statute in passing.
correct. And it was never, this reference to a violation of paragraph A was never at issue. It was the remaining portion of E1 that was at issue. Here, the legislature has granted an individual charged with simple OUI greater protection from evidence of non-consensual testing than an individual charged with a more serious OUI offense.
how do you deal with the lesser included problem?
If the legislature had intended that interpretation, as the defense suggests, then it would have said, it would have used an elements-based approach, as it does in Section 58A, as it does in the Armed Career Criminal Statute. If it had said, in a prosecution for which a violation of paragraph A is an element of the offense, you would need to read in language to the statute that is simply not there.
But how does that work practically? So I'm accused of aggravated OUI. The jury says no aggravation but OUI. And then aren't you using, let's say it was taken in violation of E. Doesn't that come in, and isn't that what
If the
that statute says? Should
if
not
the-
happen?
If the Commonwealth got beyond the directed verdict standard with respect to the, say, serious bodily injury charge, 24L, then it would have, the prosecution would not have been for a violation of paragraph A. The prosecution would have been for a violation of 24L. The fact that ultimately it comes back as a lesser included because potentially the jury didn't find a serious bodily injury does not violate Section 1E.
But didn't they use aren't they using the alcohol reading evidence to convict you of the lesser included there, which is something the legislature didn't want to allow, right? Doesn't it present a practical problem that evidence, if you're convicted of the lesser included and that evidence is in there, doesn't that present a problem?
I don't think so, because the statute says in any prosecution for a violation of.
But if a prosecution always includes a lesser included, doesn't that present a problem?
Then the legislature would have said so. It would have said for a prosecution that includes an element of.
That's assuming a lot. They're understanding not just the way the statute works, but the way the DAs prosecute and the way we interpret lesser included. That's a pretty big lift for them.
I would like to give the legislature more credit, Your Honor. It specifically says for a violation of paragraph A. As the amicus brief pointed out, in the original, in one of the original versions of the statute, it was more broadly written. And the legislature decided to more narrowly tailor it and specifically call out a violation of paragraph A.
Isn't your argument much simpler than that? Aren't you just saying that in a case where there's an aggravated OUI, this is admissible? The statute's not about what evidence may be considered after the verdict as it relates to what happened in a lesser included offense. The statute says, okay, these are the tools and this is what you can use to build your model of reality for your trial for this type of prosecution. Nothing about what the ultimate adjudication is.
Correct. That's why they use the words in a prosecution for a violation of. And I think that goes to what this court said in Bohegan, which was absolutely not dicta. In fact, the court in Moreau relied on the holding in Bohegan and said as much. The court could not have decided Bohegan based on 1F if it hadn't already kind of checked the box with respect to 1E.
Is a prosecution for aggravated OUI also a prosecution for OUI?
No, Your Honor, because the Commonwealth need demonstrate probable cause and then need demonstrate a directed verdict standard with respect to the additional elements. There's multiple additional elements depending on which OUI, more serious OUI we're talking about, but it's not just an OUI, it's an OUI plus.
But
Right. But subsumed within the OUI plus is what you first said, which is OUI.
Correct.
Okay, so a prosecution for OUI plus must necessarily, as a matter of logic, also be a prosecution for OUI.
Correct.
Okay, so if it is a prosecution for OUI, as you've now admitted, then E applies.
No, Your Honor, because it's not in a prosecution for a violation of paragraph A. The Commonwealth is alleging a violation of it
The violation term that you're hanging your hat on.
and the lack of an elements-based approach language, which this court would have to read into the statute, which is not present. The court, if the legislature had intended the defendant's approach, which would offer a blanket protection for any defendant charged with an element of OUI, as they do in many other places in the statute, they could have cross-referenced. They simply didn't do it here. They could have, the court must presume that the legislature intended what the words of the statute say. Here, the words of the statute say, in any prosecution for a violation of paragraph A. So when the violation of paragraph A appears in the complaint or appears in the indictment, 1E applies.
What do you say to the appellant's argument that 24E1, when it passed, there was only one type of OUI?
That may be true. However, again, back then when it passed in 1961, the language was more narrowly tailored. In 1986, when the 24L was passed, the consent language was proposed and ultimately was not included in that particular section. So I think that goes to the legislature's intent that this 1E section really only applies to violations of paragraph A.
Can you expand on that? What happened when 24L was passed?
Again, it's referenced in the amicus brief, I think on page 16 and 17. Okay. There was a proposal that would include the consent provision and cross-referenced section 1E. But ultimately, in the final version of section 24L that was passed, the consent provision was not cross-referenced, it was not included. I think that is conclusive of the legislature's intent with respect to whether consent is required under 24L, which is the specific question before the court. And it makes logical sense, Your Honors, that the legislature has granted an individual charged with simple OUI greater protection from evidence of non-consensual testing versus a defendant charged with more serious OUI offenses. Where there's an actual victim of bodily injury or death, the defendant's interests diminish in favor of the victims and the Commonwealth's ability to prove the case with the best evidence possible. The existence of the victim is the distinguishing factor. And if the court has no further questions, I'm happy to rest on my brief.